attorney. Just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and it's open for legal questions. So if you have a legal question or problem, I can help you in any way. All you have to do is to call our toll-free number, 877-943-9673. 877-943-9673. Your question can be about any problem you have, anything you're worried about, concerned about, wanting somebody to talk to or a different opinion. It can be about wills, trust, probate, trust administration. It can be your beneficiary not being treated properly. It can be just about any area of law. And if you have a family law situation, if you have a personal injury situation, you have landlord-tenant, all you have to do is to call our toll-free number, 877-943-9673. We already have a call, so let's go to Frankie in Tampa. Hey, Frankie.
Oh. Hey, Mr. Pippen. I'd like to ask you a question, which is, I've been dating this person for about 2 months now, and it's been about a year since I've known them. Mm-hmm. And she's 16 and I'm 19 years old. And my mom constantly warns me about dating someone who's younger than me like that. And I've come to know her and trust her. And I don't know, it's just been hard. And she's been showing me about the Romeo and Juliet law that it would be okay to date and be around each other. And for the past 2 months, we've been dating pretty much secretly, and pretty much everyone knew except for my parents, until I told them, and the concerns started coming from my parents. So, and I can see their concerns, but sometimes my mom says that if we're out together, a policeman can ask my age and then arrest me or something. I think that's kind of ridiculous. But she's said other things that concern me. But the person I'm dating is saying that it'll be all right, and I trust her, and I've been around her family, and her family like me, and they like to be around me. So I just don't know what to do.
Well, no, there's no law that a 19-year-old can't date a 16-year-old. You would need parental consent if you got married, before she's 18. But you're not breaking any laws by dating. When I was 17, my wife was just a couple of weeks before she turned 16. I started dating her when she was, 15, 11 months and 2 weeks, let's say. But so I don't see any problem at all with dating someone who's not 18, for sure.
It's just been worrying me because I don't want to let down either side, and I just.
Frankie, what they're not really, your parents are not concerned so much about dating.
Yeah.
We're concerned about what dating leads to, perhaps, and that she's a minor under 18. Mm-hmm. So as long as there's no sexual activity in the marriage before she's 18, because you're an adult and she's not, you could get yourself in trouble that way, perhaps. But, hopefully that's not an issue. And I'm just mentioning that because I think that's probably the main issue your parents are concerned about. It's not the dating.
Yeah, I'm just, my mom's usually worried about us, being alone, together, going to the mall, by herself. I'm not allowed to, have her in my car, and take her places. But
No, but you're perfectly, there's no laws being broken just because you're on a date with somebody under 18.
Okay. Thank you.
All right, just behave yourself, and you'll be all right.
Okay.
All right, thanks. All right. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. If you have a legal question, all you have to do is to call our toll-free number, 877-943-9673, 877-943-9673. 9673. And phone lines are open. Let's go to Joe in Bradenton.
Yeah, hi.
Hey, how are you?
Hey, okay, about you?
I'm doing very well, thank you.
Good. Now, my question's not like it is for most people call and they ask, a local thing or ask for, people dying or divorce. My question is on the national thing because this is starting to really kind of scare me. How can you be arrested? I'm over 50 years old. I've known people all my life who they might have had to deal with the police in my lifetime, not me, but people I know, or FBI, and they've lied their tails off. Oh, I wasn't there. I didn't know that I did this. And they never got arrested for lying to the FBI or lying to a state trooper official. They got arrested for what they did, maybe stealing something or maybe being involved with, a criminal activity. But they never got arrested for lying to the FBI or lying to the police. And for me, to know that if a police officer or an FBI agent were to ever say something to me, and I've never had contact with an FBI agent, but if I ever did, I would say to them, I'm sorry, I'm scared to death to talk to you because if I say the wrong thing, you can say that I was lying to you and put me in jail. How is it in the United States of America that you have to now be scared? Because I never heard of this happening before. The FBI can arrest you for lying. How is it that they can do that? I mean,
are you talking?
God?
Are you talking about the Michael Flynn situation?
Yes, I'm talking about that, but I'm also talking about there have been other cases in recent history where people have been arrested not for anything. They didn't do anything illegal, but they lied to the FBI when they asked them questions. That scares the living daylights out of me.
Well, I think it partly depends on whether the person has been subpoenaed, whether they're under oath, whether they're in a situation where they're giving testimony or answering questions under oath, under penalties of perjury, things of that nature.
Well, they keep on thinking of Mrs. Clinton, and she was on, before the Congress, and sworn to test, and she lied and lied and lied.
Well, I think they could make an issue of that for sure, because she's been under oath many times, and I don't know if she's an attorney, so I don't know if she's well trained to give answers with enough wiggle room to get out of it as a lie so much.
I don't understand.
Yeah.
I don't understand how some people can get up there and say, "Oh no, there weren't any top secret emails to the FBI," and then the director of the FBI could say, "Oh, we didn't see any lies, but there wasn't enough lies, or they didn't rise to the." That scares me. Do you see what I'm saying?
Yeah.
Their discretionary power is enormously terrifying to an American citizen that's been around for over 50 years and remembers a country where your rights were so important. Have there been recent laws? I mean, was it because of Bill Clinton and his lying? I mean, I'm trying to understand what happened to this country that the government can put you in jail under their discretion.
Well, let me close this off by saying that I think lying mainly only becomes an issue when you're under oath, giving testimony under oath of penalties of perjury. So, but Joe, hey, thanks for calling.
I thank you very much.
All right, let's go to Carolyn in Bradenton. Hey, Carolyn.
Hi.
Hi, how are you?
Hi, good morning. I have a question about veterans. My brother was a veteran, and he passed away. Mm-hmm. In August this year, and he left, of course, everything, and he had a will, and my sister and my brother are the beneficiaries or the executors of the will. Now, because he never used all of his benefits, like his GI Bill and other things, is that possible that they could get that benefit? Like if they wanted to build a house, he had the possibility of doing that? Is that possible?
No, I think his benefits pretty much died when he did. So the only benefits would be if he had some type of retirement account or money that he... but to build a house benefit, that doesn't pass to anyone else when a person dies.
Okay, that goes when he goes.
Yes, ma'am.
Okay, thank you.
All right, thank you.
Bye.
All right, phone lines are open. If you have a legal question, you can call toll-free 877-943-9673. That's 877-943-9673. I'd be more than glad to answer your legal question, get things untangled for you, maybe give you a little peace of mind, maybe a different direction to go. But let's go to Denise in Seminole.
Good morning, Mr. Pippen.
Good morning.
My question is, when my fiance and I get married, will my income be used to determine his child support payments, or will his do we need to keep our income separate, or how does that work?
Well, your income by itself would not be a change of circumstances for what he pays on child support.
Even though we work together, we both we're truck drivers and we drive teams, so our
No, because you get a because you get a paycheck, he gets a paycheck.
okay.
And
So
I
it
don't
won't
really
use
see
my income to determine his child support just because we got married.
No, ma'am.
Oh, that's great.
Yeah, I don't think you have to worry about that.
Thank you very much. That makes me feel better. Thank
All right,
you.
well, great. Have a good weekend.
You too. Bye bye.
All right. Let's go to John in Riverview. Hey, John.
Yes, good morning. You know, I talked to you about a month ago, and I still got a little bit of the same problem. And maybe I can clarify it a little better than I did last time.
All right, go ahead.
It was about my brother leaving me a piece of property when he passed.
Mm-hmm.
But he left his girlfriend a trailer sitting on the same property as her life estate.
Mm-hmm.
Until she passes, and she passed about 6 months to a year ago.
All right, so you have a title for the mobile home, and then he owned the land that was on.
No, I don't have the title. That is the problem. We cannot find out whose name the title is in. It was through one bank, and then another bank took over this bank, and they're way out in Colorado or South Dakota, somewhere out there. And I have gotten a hold of them with the VIN numbers and everything, and they're supposed to have they were supposed to have the mortgage on it. I don't know if I can't even find out if they still have a mortgage on it or what. But the guy that's buying the piece of property wants the trailer to stay on it. And me and him have spent 2 weeks going through the tax appraiser's office, tax collector.
All right, so the trailer was perhaps bought in another state?
No, it's bought in Jacksonville, Florida.
Okay. And you've gone to the local division of motor vehicles and tried to do an affidavit for lost title?
Right, and they say because of the Privacy Act, they can't tell me whose name it's in. And we've even gone through the clerk of the circuit court.
All right, well, it could be that you're going to have to be appointed the personal representative of his estate to have a legal authority to deal with the matter. Was the land itself in his name?
It was in his name, and when he passed, he gave it to me. The trailer...
No, hold on. Let me understand this.
Okay.
All right, so he passed. The land was in his name. How did it get put in your name? Because it was in a deceased person's name.
Through the will. He had a will.
Yeah, but so the will got probated?
Right.
Okay. And the probate is still open, or is the probate open and closed?
The probate is closed.
Okay. So you have to reopen the probate, get current letters of administration, take those to the Division of Motor Vehicles to get your title redone.
Can you do that for me?
Yes, sir.
And approximately how much it costs?
Probably be $2,500.
Yeah, that's what me and the guys worried about. Because see, the trailer has been really damaged.
Yeah.
It has to be.
Well, I mean, that's the only way you're going to... It sounds like to me that's the only way you're going to do is to get through the estate reopened so you have the legal power and authority to deal with the assets that are still in the estate. Why don't you could go back to the attorney who opened the estate to begin with. Maybe he would charge less to reopen it to give you what you need.
Okay.
Yeah, that would be probably what I'd recommend to you, actually. Go back to the attorney that opened the estate to start with and see if he or she will reopen the estate for you, and you get a current letter of administration dated within the last 60 days or so. Take that to the Division of Motor Vehicles, and that should solve your problem.
Thanks a lot. I think you just did.
All right, thank you.
And I may even go ahead and spend the $2,500 if she's going to be any higher than that.
Okay, yeah, we'll go ahead and ask. If the person, it's a she, so if she did it to begin with, I think she has the file currently, and it'd be easier for her to do it than hiring someone brand new to do it.
Thanks.
All right, no problem. You have a good weekend.
You too, ma'am.
You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and we're open for your questions, and there's openings now on our phone boards for you to be able to call in. You have a toll-free number, 877-943-9673. That's 877-943-9673. Questions can be about any area of law. If I know the answer, I'd be glad to share it with you. If I don't know the answer, hey, I tell you I don't know. Probably can still give you a little information, and definitely can give you a resource or a suggestion on how we get the information to you. 877-943-9673. You're listening to one of multiple stations all over the state of Florida. You're listening, broadcasting today from Tampa, Florida. And this radio station houses several stations at 570, 910, 860, 930, 1380. All of those stations carry the program Ask an Attorney for all about Florida law. I've been host of this show since 1984. I think it's the longest running continual program in Florida. I'm glad to be here, glad to answer your questions, glad to help you in any way I can. You're also listening to an FM station in Haines City, Florida, owned by Landmark Baptist Church, 90.3 FM. There are also multiple stations. There's a community FM station in Sun City Center that carries the program. There's a FM station in Crystal River area that carries the program. No matter where you're listening, some people are listening in other states on their computer. You have a toll-free number, 877-943-9673. Let's go to Joe in Riverview. Hey, Joe.
Good morning. How are you?
I'm doing good. 2 calls in a row from Riverview. I bet a lot of people listening don't even know where Riverview is, but I definitely do. So
it's a growing community. From what I understand, it had 2,500 people about 15, 20 years ago, and it's close to 100,000 people now.
Is that where they had the shooting last night at a bar where the bar owner killed 2 people? That was somewhere close to Riverview.
I didn't hear about that.
Okay.
I didn't hear about that. I'll have to check into it. My question is this. I've been married 5 years now. And when I had lived over in Pinellas County, when we got married, my wife had a house in Riverview, and I had one in Pinellas. I sold my things and moved in with her because she had younger children. The house has not been put in my name yet, although I've been paying the mortgage, 90% of the bills. If something were to happen where we get divorced or she would pass away, how would that fare out as far as the house goes? Whose name would it go into?
Does she have a will?
She has a will that I haven't read through the whole thing, but it was basically set up because of her young children. Because her first husband passed, if something were to happen, her daughter would be the executor, and the assets would be available for the children. But she told me that the way the law is set up in the state of Florida, which I haven't gotten into, that since we're married, that would all be null and void. Is that true or no?
Well, the provisions to her prior husband in a will would be null and void. Let me ask you this. If you ask her, I think I'm paying the mortgage, I'm paying 90% of the expenses, I think it's time my name went on the deed. What would she say?
She balks it. She revolts it. She doesn't want it. She's like, well, if that doesn't happen, that's throwing all this money for an attorney, and have to remortgage it and blah 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 blah, and so she's not willing to do that.
Well, we know if I were doing this for you, I would charge $150 for the deed.
Is that all has to happen?
Yep.
Okay, we're gonna have to do that. Okay.
Yeah, that would be that would certainly be the easy answer, an easy solution.
Okay, and I'm sorry. What was your name again? I'm sorry.
Joe Pippen.
Joe Pippen. Okay, I will get a hold of you Monday.
Yeah, never mind anyone asking me on the radio what my name is again. So, so that's all right.
All right, I appreciate that. Thank you very much.
Thank you.
All right.
All
Put
right.
my mind at ease. I appreciate it.
Well, good. That's what you should do. Is just have a deed redone.
That's all we got to do. Then we're going to do
And
it.
you're paying 90% of the mortgage payment. I would want my name on the deed for sure if I were you.
Well, that's my thoughts. So,
well, let me tell you. Let me tell you what.
you
Let me tell you what would happen if you don't do that. You would have an option at her death, if she died first, to sell the home and take half the proceeds, or you would have an option to live there for life.
Mm-hmm.
But neither one of those equate to full ownership that a deed can do if she passed away.
Okay.
Now that is your homestead. Do you still own another property?
No.
Okay.
Mm-hmm.
Yeah.
Mm-hmm.
No, so if you want full ownership, the only way that's going to happen really is if she does a will that leaves it to you, that would cause a probate proceeding, or just simply do a quick claim deed now, putting your name on the property as husband and wife.
Okay. Yeah. Now, what about the will she had set up?
The provisions to her prior husband would be null and void.
Okay.
And if you're not mentioned in that will, you would have a statutory right. I explained the homestead to you, and everything else you would be entitled to 30% of.
Okay. All right. Well, probably would be the best thing for me to get a copy of that and have you review it and proceed that in that direction. Yeah. Okay.
Now, if she says, well, I just want to do a will that leaves it to you,
mm-hmm.
The problem with that is she could do a will, on Monday in my office, and then she'd go somewhere else on Tuesday and do another will that does something different. So you have no peace of mind that would be the final thing that she did.
Gotcha. Okay. Would we have to remortgage the house or not?
No, you might. I would probably get consent from the mortgage holder to put the name on the deed.
Mm-hmm.
But from a deed from a husband and wife is hardly ever an issue like this.
Okay.
All right?
All right. Sounds good. I appreciate it, Joe. I'll be in touch.
All right, thanks. All right, let's go to Al in Tampa. Al in Tampa.
Yes.
What can we do for you, sir?
How you doing? Question is, first of all, good morning.
Good morning.
My question is, I received a timeshare from a company probably like a couple years ago. And
you received it or bought one?
I received it. I didn't pay anything for it. There was no charge.
But you have yearly maintenance and tax expenses?
Right. Well, when I first got it, it was actually paid up for the first 2 years. So, so I didn't really think anything about it.
Well, is there something you sought after? I mean, they just didn't give it to you out of the blue, did they?
Not really. It was a company that I came to know about through, an associate, and I found out, this company actually, I guess they get them from different places, across the country, over the world. So they have, probably hundreds,
Yeah, well, there are a lot of people out there wanting to get rid of timeshares. So maybe there's a company that receives them and gives them to someone else. But I don't know. You usually have to pay. Sometimes you have to pay to get rid of timeshares. But anyway, go ahead and ask your question.
My question was, that's basically what I'm getting at. I'm looking at, because I haven't had time to use it. And the first 2 years it's in Daytona, so I don't have time. I work a lot, so I didn't have time to use it, and I go different places for vacation. So
why don't you call them and ask them if they'd take it back?
That's not a bad idea. But
yeah, that's what I would do. I mean, somebody gave it to them to get rid of, probably, and now you got it, and you want to get rid of it, so see if they'll take it back from you.
And if not, what would be
Well, you could find someone else who would like to have it and give it to them.
Right.
Some charities take them as gifts, and then they try to sell them
Okay.
or use them for, their charitable purposes somehow.
Right. Okay. Yeah, not a bad idea. I appreciate that.
All right.
Great. Thanks a lot.
Thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. We're about halfway through the show. If you have a legal question, 877-943-9673. That's 877-943-9673. Phone lines are open, and let's go to Hirsch in Jacksonville.
Hello.
Hey, how are you?
Hello. Good morning.
What's your first name?
Hirsch.
Okay.
My question is, what is the Florida law regarding signing a contract for a travel membership? It's not a timeshare. It's like it's a club that they're supposed to help you to buy better deals on hotels and airplane tickets and cruise. But I signed that on Sunday, and I want to cancel it.
How were you approached? How did you find this company?
They called me saying that I won some prize, and they gave me some free, supposed to be some deal. But that's, after I saw it, it's not really a deal, because if I get a free ticket from them, I'm supposed to stay in a hotel. Then it will be very expensive. It's like they give me a flight from here to Cancun, but I have to pay like $300 a night in Cancun for an all-inclusive hotel, which I can find much cheaper on Travelocity or any other thing.
Do you have the name and phone number of the person who called you?
Yes.
We'll call them back and tell them you want to cancel, and you want to know the procedure to cancel the contract and see what happens.
I did that, and they say, okay, send me an email, but that they haven't reimbursed my credit card yet, and that was on Tuesday.
Well, call your credit card company and put a block on the charge.
Okay. So there is no limit. I mean.
Well, I don't know. Did you just sign something online, or they faxed?
No, I went to an office in San Agustin.
You went to an office and signed something they had sent you to print out, and then you faxed it back to them?
No, I went to an office here in Jacksonville.
Oh, I see.
And I went through a presentation, and after that I signed, and, that was on Sunday, and Tuesday, Monday I tried to do arrangements with him, and I come to realize that it was not going to be a good deal.
Yeah, no, you call your credit card company, cancel the credit card charge. You make sure you have a copy of the email you have that canceled the contract soon after you signed it.
Okay.
And if I were you, if it were me, I'd probably go back to the office in St. Augustine and get some confirmation that it's been canceled.
Okay, I will do that.
All right.
All right, thank you.
Thank you. All right, let's go to Sharon in Jacksonville.
Hi, Joe.
Hey, how are you?
I'm good. I have a question about a title to a property.
Mm-hmm.
My husband and I have lived in our house for 40 years, almost, and there is no mortgage. The deed is in my husband's name, and he does have a will, but what I'm wondering is whether or not it should be in both our names.
Well, if it's in his name and he dies, it's going to go through probate before it gets to you, assuming he left you everything in the will.
Yes.
And that would cause a probate process.
Okay.
Getting it from out of a deceased person's name with no beneficiary, which that usually what happens with a deed. That would cause a probate process.
Okay, so it would be better if we did that now and had my name on it as well.
Absolutely.
Okay. All right. Well, that's all I need to know. I appreciate your help.
All right. The only disadvantage to that is if he had a will, and how much did y'all pay for the house 40 years ago?
Oh, $50,000.
And what's it worth now?
Probably $250,000, maybe $300,000.
If it was in his name when he died alone, it would get a stepped-up cost basis.
Well, we do. I am aware of that, but I thought that if you had good records on the improvements that you had done to the property,
yes,
that
would increase the cost basis. Right.
I don't think it wouldn't be as bad.
I like to tell people what I would do. If I were you, I'd want the house in my name. I wouldn't care that much about the cost basis. I would definitely have the peace of mind that this is my house if he dies, and have it done without a probate proceeding early.
Okay. All right.
And
Well,
who knows? We might not even have a capital gains tax by the time you pass on. Who knows?
yeah, that would be great.
Yeah, well, they're trying to get rid of all these estate taxes and everything, and let you keep what you earn and pass it on to your family. Hopefully that all happens.
Yes, I agree. I hope so. Okay.
All right.
Thank you very much.
All right, let's go to Don in Jacksonville.
Good morning, Mr. Pippen.
Hey, we have a hat trick from Jacksonville, 3 in a row.
Oh, yeah. Actually, it's Atlantic Beach.
Well, that's close enough.
Yeah. I've got a quick question for you. My wife and I just paid a mortgage off on our home, and we haven't received the documents back yet from the mortgage company. What specifically do I want to make sure that I'm in possession of, and do I need to have the deed re-recorded with no lien on it?
No, sir. What the mortgage company will send you is satisfaction of mortgage.
Okay.
And they should do that and record that and send you the copy from the court that shows that it's been satisfied in full, and then that's all you have to do. Then the house is, of course, is not subject to the lien, to the mortgage lien.
Okay, and that's adequate. I don't need to do anything else in the future.
No, sir. That gives you a free and clean property as far as the mortgage goes.
Okay, perfect. Okay, well, thank you so much, and have a great day.
All right, thank you. All right, speaking of Jacksonville and 3 calls in a row, we do have offices there. We have several offices in Pinellas County, several in Hillsborough County, several in Polk County, offices in Palm Coast, Jacksonville, Clermont, Leesburg, the Villages. We have Sarasota area, Manatee, Lakewood Ranch, Sun City Center. We have 20 office locations around Florida. You can learn more about the firm by going to our website, www.attypip.com. If you'd like to receive our free poster sheet, which is a full-size sheet all about wills and trusts and estate planning, stay tuned, and I'll give you that information right after I go to Marla in Holiday. Hey, Marla.
It's Maria. Sorry.
Maria. Oh, I'm sorry.
Yes, sir. It's okay. A lot of people call me Marie.
Well, no,
Marla.
I was looking and I see that it's Maria on my screen, and I was thinking Marla when I thought that was an L there, but it's not. But go ahead.
It's okay, sir. I've had
my producer needs a reason to harass me some, so I just gave him one. So
no, I've had this question. I actually have a couple, but I have a second loan that was bought over by an aggressive lender. And the original loan was for 15 years. The first 10 years, I paid interest on the first lender. When they took it over, they're charging me principal and interest for the next 5 years. And I'm wondering if that's legal or not, because I've asked them to modify it several times, and they're saying that it doesn't meet their, I guess, qualifications or something for modification. So in a way, they're forcing me to want to file bankruptcy because what happened is even after I graduated from school and I'm working, it's not enough to pay, all my bills. And then so my first question is it legal for them to do that, or should I seek an attorney? Because I've been trying to modify it according to my income, and they refuse to.
Okay, so you're asking me, do they have to modify a loan because you want them to?
No, because of my financial situation, sir.
Do they have to modify because of your financial circumstances? No. So your option would be to go somewhere else and get someone else to modify it for you.
Okay, I see.
See, they've got you on the hook, let's say. They don't have to do they don't have to do anything. You want it modified, they won't do it. Find someone else to do it for you.
Okay, I see. All right, then. Well, that was my question.
All right. Well, thanks for calling.
Thank you.
All right, thanks for calling. Okay. Phone lines are open. If you have a legal question, you have about 15 minutes left in the show. Not that much time, so give us a call, and if I can help you, at 877-943-9673. 877-943-9673. By the way, you might have been watching today on Facebook Live. We're streaming live on Facebook Live, and we're also streaming live on WeBeam TV. So, WeBeem.com. And I always thought it was BEA or BEEE. So it's EA. Oh, I'm sorry. It is EA. WeBeam, WeBeam TV.com. And we're streaming live there, and we're also on the Facebook Live. So if you're haven't got that and you're close to your computer and Facebook, you could go even watch a segment of the show. If you'd like our free estate planning poster sheet, there are 1 or 3 ways you can get this. It's a full-size poster sheet all about estate planning. It's good for you if you would just going to be wanting to update maybe your estate plan or thinking about getting a new plan started. If you would like to have it, you can get it 1 of 3 ways. You can call our toll-free office number, 1-800-226-3529. That's 1-800-226-3529. Go to extension 200. Ask for Laura. She'll take your name and address and be glad to mail that right out. If you would like to have it by text, you can text me your name and address to 727-667-3967. You can text me your name and address to 727-667-3967. If you'd like to request it by email, you can go to Joe, Joe, at attypip.com. Let's go to Steve in Dunedin. Hey, Steve.
Hello, good morning. Thank you for taking my call. I was just calling to maybe get some information regarding, I've got a girlfriend that I've been with for over 20 years, probably about 22 years.
Mm-hmm.
And she's been separated from her husband for since 1994. We've been together for many years. And I was wondering, what steps do I have to take to actually get her, because she doesn't have any relationship with the guy. They do have a kid, but the kid's already like 23 or 4. They've been separated. They no longer are together with the child.
Mm-hmm. But they're still married.
They're still married, and the kid's grown up, but she doesn't see him. There's no custody battle or anything like that. She's just simply divorced. Separated. And we've been together for 22 years, and she has no contact with him whatsoever. Basically, it's kind of like an abandonment. They were, separated completely for 22 years or longer. I mean, they've been divorced since 1995 or 6.
Mm-hmm.
Separated. They've been separated for many, many years, and they haven't been together in many, many years. And we've been together for, 22 or 23 years. She has no contact with him whatsoever. She's completely estranged from him. And I was wondering if what steps would I have to take to basically get her to get a divorce, since she has no contact with him. But, that's what my question was. How do we go about that?
So she would be willing to follow the divorce?
Yes, of course, yes. She doesn't love him or want to be with him anymore. And they had a kid in 1994.
Mm-hmm.
And
do you want to adopt the kid? Are you close to the child?
Yes, but he's a grown man, and
so you can do an adult adoption, though.
I'm
All right.
sorry?
Well, yeah, you can do an adult adoption.
Uh-huh.
Would her would her husband object to the divorce?
I'm not sure. That's what I'm asking.
Yeah.
I'm sure.
Actually, it doesn't. In Florida, there's a no-fault divorce. So I think what you should do is to call our family law attorney. Her name is Catherine. And she can go through the procedure. In Florida, there's no fault divorce. There's a person under these circumstances. I don't usually encourage people to get divorced, but under these circumstances, if you need to talk to a family law attorney, her name is Catherine. She has a local number for you at 586.
Okay, wait, let me get that, sir. Okay, hold on one second. 586.
3306.
Is that an area code 727?
Yes, sir. Yeah, it's local for you. 586.
586.
3306.
3306. Okay.
Extension 112.
All right, great. And her name is Catherine, right?
Yeah, and she also has her own radio show on a different station on Saturday morning at 7 o'clock.
Okay.
So
all right.
Be sure you tell her that you listen to my show and not hers when you call. No, I'm just kidding. But, all right. Our thanks, Steve. Good luck to you.
Thank you very much.
All right, thanks. A lot of people listen to Catherine at 7 on a different station and then turn over and they listen to both of us. And sometimes we do email blasts that have us on each other's show. So her name is Catherine. You want more information about her, you can just contact me. Let's go to Chris in Palm Harbor.
Hi, how are you doing?
Good, Chris, and you?
Good. Question. My fiance's father passed away a couple of weeks back. They're up in Pennsylvania, and he has a will, and his wife is the one that actually has a physical copy of the will.
Mm-hmm.
But she's not releasing the will to any of the siblings, and when we contacted the attorney up there that drafted the will, the attorney said that we would have to get the will from her, and nobody knows, I mean, she's got it in a safe, and she's like, well, you don't need to see it. But nobody knows what is in the will as far as, what he wanted done with his properties. And
all right, well, let me tell you, I don't know Pennsylvania law, but I can give you the answer of what the same such circumstances would be in Florida, and I assume it's somewhat the same in Pennsylvania. You would hire an attorney there to demand that the will be filed. In Florida, there's a law that if you're in possession of someone's will and they die, you have 10 days to file the will. So you can use the statute in Florida to force someone to file a will who's just sitting on the will, refusing to file it. And I'm sure there's something similar in Pennsylvania, but of course I don't practice there and don't know the statutes.
Uh-huh.
So the first step would be to hire an attorney to write her a demand letter to file the will. And then if she doesn't comply with that and there's a statute that gives her some deadline or so, you could possibly find her in contempt of court or force her to file it. Now, having said that, there's one thing I think you should know. If he died and they owned everything jointly with right of survivorship, if that were to be the case, then there'd be no assets that would be in the probate estate, because jointly held assets between husband and wife are stronger than the will. So the will is only going to really come into play if husband died with assets just in his name.
Well, I mean, not all of the assets are like hard property. Like he has like a gun collection and tools, things like that. That the siblings are, they'd like to divide up, but they, they're kind of caught.
Okay.
And,
well, that's a good reason.
That she's going to start liquidating these things, and
that's a good reason to get a local attorney in Pennsylvania involved, and to write her a strong letter to file the will right away, and that they have reason to believe that there are personal effects mentioned in the will that the family would like to have.
Okay, and when you say she, her attorney is a female as well. Should the attorney be filing this thing as record, or is it something that she would have to?
It sounds like the wife has possession of the original will, so the attorney probably only has a copy.
Mm-hmm.
So assuming those are the facts, the wife's got to be the one to file the will and take action. And she doesn't have to hire the attorney who drafted the will to do it. She could have another attorney draft it. So the best course is for y'all to have your own attorney write a demand letter to file the will and to freeze because you believe there are personal effects that were left to the family, and kind of put her on notice that you're possibly aware of that, and not to get rid of those assets and to file the will. And the attorney in Pennsylvania will know exactly what to say once you give him the facts.
Okay, I appreciate it.
All right, thank you.
Thanks. Bye.
Let's go to Michael calling from Tampa. Hey, Michael.
Hey, Joe, good morning to you.
Good morning to you.
Hey, my question is, I have several properties, and actually I'm single, but if I was to get married again and was to get divorced, would my wife have any claim to property that I acquired prior to our marriage?
All right, well, the question is basically you should have, for absolute safety, you should have a premarital agreement. And the premarital agreement, she's going to waive There are different rights concerning divorce as opposed to when you die.
Okay.
So you want to deal with both of those issues, and you can do that with a premarital agreement. Okay. Now, the premarital agreement basically says what's mine is mine and what's yours is yours, and I can do whatever I choose to with mine, and you waive your right to your spousal right to my assets if we're divorced, and I waive my rights to your assets.
Right.
It also controls when you die that she's waived her rights. So she's waiving rights if you get divorced, and she's waiving rights if you die, and she does likewise on the other side. Now, having said that, you could have a wonderful marriage and you want to leave her, half of the estate or whatever percentage you come up with. You can override what you want to do for her in your will. She's just waived her right to it, but you could still leave her whatever percentage of the estate you wanted to, regardless of the premarital agreement.
Okay.
So you got the best of both worlds. She's waived her rights, and you can do what you want to with your assets. And if you want to leave them to her because she's a great wife and great marriage, and you want to take care of all of her needs, possibly if you should die unexpectedly, then you can still do that, even though you have a premarital agreement.
And just throw that in the trust.
Yes, sir.
Okay. I do listen to you.
All right.
Okay. Thank you. Appreciate it.
Thank you. Thanks for listening. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. Phone lines are still open. We have time for one or two more calls if you want to call in, and our phone lines are open now at 877-943-9673. That's 877-943-9673. To learn more about our firm, we have a website, www.attypip.com. We have pictures and bios of all of the attorneys that we have. We have 20 office locations. We have all that information on. We even have, which might be a little bit unusual for attorneys, we have a fee schedule. So if you wanted to go to the website and see how much we charge for a will, the information is there. If you wanted to see how much we would charge for a trust, the information is there. If you'd like to have our free estate planning poster sheet, there's one of three ways you can get that. You can call our toll-free number, 1-800-226-3529, 1-800-226-3529. You can email at Joe, at attypip.com. Or you can text me at your name and address to 727-667-3967. Text me your name and address at 727-667-3967. And again, you're listening on Facebook Live, or we're streaming on Facebook Live in WeBeam TV, WeBeam TV.com. And if you want to, maybe you've learned something today that would be really helpful to someone you know in your family. You could even watch the show on Facebook if you wanted to, as a repeat. Let's go to Steve in Inglewood.
Good morning, Joe. I have a friend, teacher, who was let go from her teaching position for what I believe are not correct reasons. Accordingly, I'm wondering how I might proceed with this. She has been unemployed for a few months, and I think that this situation with the school is preventing her from getting a new job.
Was she fired for reasons of discrimination, or... Well,
no.
If you could describe the reason in one word, what would it be?
Well, they suggested that she'd been drinking on the job.
But they had no proof?
No proof whatsoever.
Yeah. All right. Hey, Steve, let me say this. We're less than a minute left on the show. If you want to call me, it's 727-586-3306, or send me an email at Joe, Joe, at attypip.com. I have an attorney I can refer to you that can help you with an employment issue.
Excellent. I appreciate that.
All right,
Thank you.
thanks. All right, thanks for listening to Ask an Attorney, all about Florida law. Hey, you have a great weekend. Be safe. Be back next week the same time. So long.